Hi, my name is David P. Shapiro. I'm the owner and managing partner of the law offices David P. Shapiro, located in San Diego, California, where my firm helps good people regain control of their future when charged with a crime. In this video, I want to talk to you about the significance of the age of the alleged victim, of the accuser, particularly in a sexual assault case. It is very, very important for a number of reasons, both from an emotional standpoint, if the case were to get before a prosecutor, before a judge, before a jury, and then also from a legal standpoint as it relates to the different types of punishments in general you could be facing based on your age, based on your accuser's age, when being investigated for or being charged with a sexual assault crime or a sexual assault allegation. Well, the first thing is, right, just by common nature, by common sense, the younger the alleged victim, the more emotional reaction you're going to get from potential jurors in a case. The more of an emotional reaction, even on the front end, you're probably going to see from law enforcement investigating the case. The more risk, arguably, that law enforcement could be biased and not really do a fair and thorough investigation when you're dealing with a younger alleged victim. Because of the fact that there's this instinct, this human nature to protect our young, to protect our youth. And there's a lot of value in that from a society standpoint. But the concern that we have as criminal defense attorneys is the law, whether the accuser is 8 years old, whether the accuser is 80 years old, whether the suspect is 19 years old, or whether the suspect's 90 years old. It should not matter as far as what the burden of proof is. Legally, it cannot matter the age of the accuser, the age of the suspect. But it is something that needs to be taken into account, and it's something you need to think about, especially if you're taking your case all the way to trial, which is your constitutional right to do so. How is a jury going to see this case? What type of jurors are we going to want on this case? What are some things that we may want to get out right away before a jury to get them talking during the jury selection process? A lot of times, people will say stuff during jury selection about why they're not a good juror for the case, and the defendant or their attorney is like, oh my God, that was awful, right? Hearing them say, oh, I believe your client's guilty and I hate you because you represent him or her. Our approach is that's beautiful in the sense that we're getting an inside look at what type of juror that person could possibly be. And now we know to get rid of them before they wind up on that jury and are saying that stuff behind closed doors during deliberations, right? So it's important to address it and not to run from it, especially when addressing a jury, when picking a jury in a case involving sexual assault of a minor, is to get that stuff out there, watch people's emotional reaction, and you'll get a better idea of what type of juror they may or may not be. Now, from a legal perspective, it is extremely important whether the accuser is under 10, whether the accuser is under 14 at the time, whether the accuser is under 16, and certainly 18 as the legal age of consent in California. But sometimes some things that get overlooked in sexual assault cases are the age, and not, everyone's focused on what's being accused, but not really focused on when they're saying it happened, right? A lot of times these kids or these minors will say, oh, I think it happened between this grade and that grade, or it was one of these 2 or 3 summers. Well, a lot of times that's really important, right? That ambiguity is really important. Not to say that nothing happened, not to even say that nothing, that something won't be able to be proven beyond a reasonable doubt, but your best defense may very well be, yeah, well, something definitely did happen. My client admitted to it, to anyone who would talk to him about it, to the cops on a controlled call with the accuser, so on and so forth. And no one's condoning this type of behavior, but there's still an element of these offenses that require the prosecution to prove beyond a reasonable doubt, same standard as any other element of a crime, that the accuser was the age that's necessary as the case is charged. So let's say, for an example, the accusers, they're thinking they were 13 or 14 at the time some sexual assault happened, right? Well, does it make it any less terrible, any less awful, any less serious? Perspective, probably not. It really doesn't, right? It's terrible no matter what. But from a legal perspective, it's a big deal. It's a big deal because if the accuser was 14 at the time, a lot of instances you would go from an 8-year maximum offense to a 3-year maximum offense. And from an 8-year maximum offense where you're serving, let's say, you could be expected to serve anywhere from 67 to 85% of it, to a 3-year max where you're serving no more than half. So think about that gigantic difference just based on what day. Were they 13 and 360 days, or were they 14 and 0 days at the time of the alleged act? Really, really important, really something you and more importantly, your attorney and your law firm should be honing in on. Not just what is the accusation, what can be proven, but not to overlook the first element is that the accuser was of a certain age at the time of the allegation. A lot of attorneys will overlook, and you could gain a lot of credit, as we have seen. We don't condone this conduct. Most of what they're alleging may very well be proven, but you convict because, well, it's close enough. Whether it's a sexual assault case, whether it's a DUI, whether it's a murder, no matter what the allegations, no matter what you may think of it, no matter what the consequences, the burden of proof remains first and foremost on the prosecution, and a burden of proof beyond a reasonable doubt. Where, and for circumstantial evidence where there's no real concrete evidence and there's speculation about dates, is there a reasonable interpretation of the evidence that supports innocence or supports not guilt to a specific charge? And, I think what's important for people to understand too is if you're in a situation, you go to trial on a case where your accuser is saying they were under 14 and, there's some doubt there about whether they were 14 or 13 or under 14, more importantly, if you beat that charge, it doesn't mean you get to go home. In all likelihood, you're just going to be convicted of a different offense. Arguably a less serious offense, possibly not even a strike offense where you're serving max halftime as opposed to 2/3 to 85% on a serious or a violent felony. A violent felony if you're serving that type of credit. But it's still really, really important. You may be convicted of a significantly lesser offense, and that may be your best strategy going into a case. Each case is different. Just want to import the importance in this video of understanding that the age of the accuser is really one of the main things that need to be proven, one of the main things that should be looked at, often is overlooked. So if you find yourself up against sexual assault allegations, whether the 17 at the time, 12 at the time, 14 at the time, 13 and a half at the time, make sure you hire a law firm that has the local experience, that has the understanding, and that handled these types of cases before, that knows what to look for, knows how to hold the prosecution. A very small handful of those firms that could do that at a very high level. So if you have any questions about a sexual assault case in San Diego and you or a loved one are accused of such, please give my firm a call, 619-295-3555. Again, David Shapiro, San Diego criminal lawyer, 619-295-3555.